it fast enough. I knew I had to get here. I said, well, I know you probably already know about this, but you might want to show your girlfriend who has 3 kids this, but you've probably already beefed her on it. And so I went to try to pull up the film clip on geotagging, and I didn't get it right away. And I said, I have to go to class. I'll show it to you at the end of the day. And he goes, what's geotagging? He's a smart guy. He loves Facebook. How many other officers do you think? What's geotagging? Was that mom? It's like, how many not law enforcement? You know, the mom in that news clip. How about the lady where the cameras show up at her house? And yeah. Okay. Now, how else might social networking sites turn officers into roadkill on the information highway? I've only given you the PowerPoints slides I thought you needed for content that had information content. So don't worry if it's like, oh well. And we'll do the test before you leave here. Okay. Officer Von Etienne clearly had not thought about Facebook and courtroom credibility. He arrested Gary Waters for felony possession of a 9mm Beretta and a bag full of ammunition. Felon in possession of those things. The case went to trial in Brooklyn, and it rested in large part on Officer Etienne's credibility because it was a he said about what happened. The defendant Waters claimed that Etienne stopped him, beat him up, and then planted the gun on him to justify the beating. When the case started, the defendant was going to focus on Etienne's use of doctor-prescribed steroids and argue that could have caused an irrational rage. And before you start thinking baseball, I, 2 weeks ago, took 2 steroid pills because I was getting ready to fly out that morning to a remote fishing lodge to go for a prepaid fishing trip. And I woke up that morning and my left hand could not close and I could not grip a fishing rod. And I'm thinking, well, if I wasn't due to fly out this morning on a not cheap remote wilderness lodge fishing trip, I'd just wait for this to go away and see a doctor on Sunday. But that wasn't the case, so I went to a walk-in place and I was prescribed 2 low-dose steroid pills along with an anti-inflammatory, and I took the 2 pills, and by the next morning I was fishing with the bears. So don't just think it's performance-enhancing, muscle-building. Steroids get cortisone is a steroid. My husband has gotten a shot of cortisone in his heel for plantar fasciitis. I don't know what it was prescribed for. But, you know, then there's that whole thing of steroid rage kind of thing. If I was a prosecutor, I would have said to officer, don't worry about it. Number one, we'll show doctor's prescription. I'll put your doctor on the stand. And those rages are very rare, and the amount you must consume, it's the kind that the Hulk guys consume before it would have that effect on you. So I'm not worried. This is talk about reaching, but don't worry about it. We'll take care of it. But then the defense got a gift that kept on giving, and that was Officer Etienne's own postings on the internet. That was how it made national headlines. That was the caption for national headlines this story made, because it's real. The officer who posted too much. The day before trial, the jurors heard that the day before trial, that is the day before he was going to be testifying in front of them, and the case rested on them finding him credible. The jurors learned that he posted his mood. Remember the man in the box. I don't care what mood you're in. He posted his mood on his MySpace account as devious. If you look it up in the dictionary, and the defense will have a dictionary, and the defense will say, so yesterday you posted your mood as devious. Yes. Officer Etienne, look up the word devious, and please read the definition to the ladies and gentlemen of the jury. And what he would be reading is departing from accepted or proper way, misleading. Jurors also learned that he'd posted on his Facebook page, Officer Vaughn is watching Training Day to brush up on proper police procedure. Anybody ever seen the movie Training Day? I'll tell you, Jensen, Denzel Washington stars as a narcotics officer who does not hesitate an instant to break any and every law, including homicide, in his own private war on drugs. And Vaughn says, I'm watching this to brush up on proper police procedures. Then the defense, don't ask me how they discover these. All I know, click World Wide Web. Somehow it gets out there and somebody finds it and, you know. Oh, by the way, there's a whole cottage industry now. Google e-discovery. There are people making a living doing electronic discovery for defense attorneys in criminal cases, for plaintiffs' attorneys and defense attorneys in civil case, for insurance industries who are having to pay out claims, for workman's comp, all of that kind of stuff. Because this is the kind of stuff you find. The Largent versus Reed, you find posting of somebody who's supposed to be severely disabled and can't stand long enough to work, and they're parasailing and hiking up, you know, the Hawaiian volcanoes and things like that. So they discovered that he had posted a comment, not on his page, elsewhere, about some video clips that were posted on this other site of arrests. And one of them had to do with an officer punching a handcuffed man. And he posted a comment. If he wanted to tune him up, he should have delayed handcuffing him. If you're going to hit a cuff suspect, at least get your money's worth, because now he's going to get disciplined for a relatively light punch. What's the defense in this case? What's the defense? I told you what it was. What's the defense? No, what is the defense? I told you what the defense was. That he beat him up and planted the gun on him to covering up beating up, right? And he's talking about, well, if you're going to punch somebody, delay handcuffing them and make it count. Because you're going to be doing, that way, when you go on vacation, at least you would have gotten your money's worth, right? And I'm watching Training Day for proper police procedure when Denzel Washington assaults, beats up, and kills people that he happens to disagree with. What do you think happened at trial? What? Well, the defendant was, I don't know what happened to his credibility, but the defendant was convicted of the misdemeanor charge, but he was acquitted of the felony. And he's a prior convicted felon. So we got a guy, a felon on parole with a 9mm gun and a bag full of ammo that walks on the felony charges. How? Oh, I'm sorry, that was my thing of where he commented on the handcuff, punching of the handcuffed guy. That's a stock photo I pulled off. How many of you, of course none of you would talk like that, but how many of you can imagine cops talking like this? Yeah! You know how I know you can imagine it? When he said if he wanted to tune him up, what does that mean, tune him up? Yeah. Yeah. If I asked one of my parents, what does that mean? My dad might, in context, figure it out because he's a master gunner, E9, you know. But my mother, God rest her soul, would have said, oh, is he talking about music lessons? I mean, but you all knew exactly what he meant, because that's how we talk. So we can imagine that. And as Officer Etienne commented after trial, would you please read this, Recruit Tilly?
You have your internet persona, and you have what you actually do on the street. What you say on the internet is all bravado talk, like what you say in the locker room.
So the conduct isn't new, but it's clicking and it's going on the World Wide Web, and that's what we're not preparing people for. He even said afterwards, he said, it paints a picture of a person who could be overly aggressive. You put that together, it's reasonable doubt in anybody's mind. So he didn't, at least he took responsibility. He didn't say, well, that jury is just crazy. You know, he took responsibility about how that could leave a reasonable doubt in the jury's mind. Now, if it can leave a reasonable doubt in the jury's mind in a criminal case, what's it going to do when that defendant who walks on the felony charges turns around and sues him and the department for excessive use of force in the civil trial, where the standard is preponderance? Okay, then we've got the whole issue of them not having to find it, but me, the prosecutor, having to get it from you and turn it over to them. I'm going to be talking a lot more about Brady versus Maryland when I come back in November. I'm going to be talking a lot more about it. I'm only going to touch upon it here for purposes of internet and how they may not even have to go looking for it. Because the U.S. Supreme Court case of Brady versus Maryland said this. Would you read this, Recruit Teft?
Prosecution and police have a duty to turn over exculpatory evidence. Includes evidence that defense might use to impeach a prosecution witness, including officers.
Exculpatory evidence, you'll learn when I come back, is anything that might tend to negate the defendant's guilt. It might be argued, and it was, and we lost in Brady versus Maryland, that a witness's credibility doesn't, just because they're not telling the truth, that has nothing to do with whether the defendant did it or not. We lost. The Supreme Court said we have an affirmative duty to turn over to the defense anything they might use to impeach. Impeach means attack the credibility of a prosecution witness, including police officers. Now, this has taken on real special meaning in Alaska. And the reason it's taken on real special meaning in Alaska is our United States Senator Ted Stevens was convicted of failing to report different gifts and gratuities on federal forms in which he was required to report them. And they were comprised of things provided, allegedly, by Bill Allen, who was president of Vico Corporation, an oil company, and who had lots of money. Bill Allen was a critical key witness for the prosecution. And there were things about Bill Allen that weren't turned over to the defense. Senator Stevens was convicted shortly before his reelection, and even though he was convicted of multiple felony counts, he barely lost. I don't think there's anybody, including Senator Mark Begich, who got elected, that thinks he would not have gotten reelected except for having been convicted. After that he lost the election and his convictions, the Attorney General of the United States of America, Eric Holder, went into court and dismissed the case against Senator Stevens because an internal investigation demanded by the judge in the case, as the defense started finding out things that had not been turned over, the judge ordered an investigation. There was an investigation. There was a long, lengthy report. DOJ did its own separate investigation. An AUSA working on the case during the course of all of these investigations committed suicide. And his wife said it was largely because of this whole investigation hanging over his head and the possible. But we take a case against a U.S. senator. We, I think, very clearly cost him his Senate seat, and he's one of the most senior senators in the Senate. And I'm not passing any judgment on the prosecution's evidence or case. I'm just saying what's at stake here. And after he loses his seat, the case and the cost of the prosecution, the case gets dismissed because of Brady violations. In the wake of all of this, and congressional hearings where DOJ is being called on the carpet, in the wake of all of this, DOJ is now mandating every AUSA go through Brady training again. And you can imagine it has a special resonance in Alaska. And Brady applies to the state as well as the feds. So everybody's gotten real sensitive to this. So, because of this, the defense attorneys, the National Association of Criminal Defense Lawyers, not just because of this, they were saying before this, but now they know they're going to have the ear of a judge. It's all a whole different ball game because we've got this high-profile case of Brady violations that resulted in this amazing result of the Attorney General of the United States, and so everybody's kind of tuned more into this. So the defense bar is urging defense attorneys to file early Brady motions for electronic impeachment material. They don't even have to file the motions. So if they don't file the Supreme Court said it's our duty. It's not triggered by them asking, but they're filing it to key us and the judge in. And because of that, which means I got to go to you and say, what do you got on the internet? I need to look at it. I need to see if any of it, under the rules of evidence, which we'll look at when I come back, would be admissible to impeach your credibility or relevant to the defense, like the Etienne thing. So the National District Attorneys Association, a lot of prosecutors' office are establishing in-house procedures. If you Google Brady lists, LA District Attorney's Office, Seattle has one, they're developing an in-house procedure for prosecutors to gather Brady information on police officers. And if there's enough of it that could make you not a credible witness, you end up on the office's Brady list. What do you think will happen if a police officer's agency is told by the prosecutor's office, don't send us any cases with so-and-so as a witness because we have to disclose this and it's just going to muck up the whole case? They can't perform a vital job function, right? Most places can't afford to put you on a desk full time and do nothing else. So, and you can say, well, is privacy protected? Brady doesn't say I only have to give over stuff in the public venue. Plus, it can be hacked. We've seen how much privacy protections work, and I don't want to be sandbagged and have the defense surprise me with it. And in addition to having to come up in trial and I'm unprepared, prepared, I've got a motion against me for prosecutorial misconduct for failing to meet my Brady obligations. And it's like, I'm very sensitive about that, so I'm going to be putting the burden on you to turn it over to me. Now, just because it gets turned over doesn't mean it gets admitted to trial. We'll look at the evidence rules when I come back. But you saw Officer Etienne. Brady versus Maryland applies to police and prosecution in criminal cases. The civil rules of procedure apply to you as a witness in a civil case, like a lawsuit against you and your department. I use use of force because it's the one we most common. False arrest, there's all that kind of stuff. Use of force is just one we can all really grab onto. So, what the civil rules say is they can discover any non-privileged information that might be relevant to their claim. Non-privileged is not the same as private. Non-privileged means anything not subject to the attorney-client privilege, anything not subject to a doctor-patient privilege, anything not subject to spouse privilege. That's what privilege means. It doesn't mean private. In a civil case, reasonable expectation of privacy comes out of Fourth Amendment, right? Civil case, their expectation of privacy is no shield against relevant information. We saw that in Largent versus Reed, right? Give over your Facebook password and username and password because there's a good indication. I don't know what offer of proof they gave to believe they'd find that, but the judge thought there was some kind of case made that they might find relevant information on the Facebook page. Read that last paragraph for me, Recruit Barrett.
Local attorney representing family of man shot by police has requested access to Facebook pages of all 57 officers who were at scene.
That arose out of Albuquerque, New Mexico. Every time I teach this, I check to see if there's been any reporting about whether they got it or not. But that's what we're talking about. Do you think you're going to get 57 officer Facebook pages that are pristine, unsullied, and pure? I don't know. I sure wouldn't want to be rolling those odds. Oh, now, there's articles. I have another article that says, lawyers finding treasures for cases on Facebook. And that's where you learn there's a whole cottage industry now of people making a living doing e-discovery for lawyers, civil, criminal, that and the treasures the lawyers find on Facebook pages to impeach the credibility of witnesses. It's not just cop roadkill on the internet that I think has become a very, very, very serious problem for us. In some ways, I think a much more serious problem from my frame of mind, because it's an ethical one, is cop road rage on the information highway. Do any of you tune in to any online law enforcement websites like policeone.com, officer.com, lawofficer.com? I have written and am still writing for all three of those. Are you aware at the end of a lot of the stuff there is a place for reader comments? Okay. Have you checked out any of the comment sections? Especially, well, I won't name of those three the ones that has the most colorful comment section because I get paid to write articles for them. And I've written several articles about cop road rage on the information highway. And I found that many of the officers that on one of these Facebook pages, you cannot post a comment unless you work in the law enforcement profession. Others sometimes, I think, are open to the public. The only reason I can post a comment is because I write for them and I've been cleared by them and I got assigned a username. I'm not a cop, but I mean, you just have to work in the law enforcement profession. Dispatchers can comment, prosecutors can comment, and you know, it's not just sworn police officers that can comment. And it's amazing to me that many of the commenters, because I have put one of the comments to one of my articles about, let me tell you, here's some public response to some of the comments you guys are posting. And I got a bunch of comments. You mean this is open to the public? They didn't even know, they hadn't even informed themselves enough to know that that page is open. All my articles, there are certain sections of these sites that are secured, that the public can't get to. And you can understand if we're talking about tactics that we don't, you know. My articles don't involve those things, and most of the websites are open to the public, and the cops posting these just as, I don't know, they were just ignorant. They didn't, and the comment said, oh my God, this is open to the public. And I said, yeah. So, I'm going to show you a couple of comments, and they're not rare, and they're not exaggerated, that I encountered. And I will confess to you, given how many of these there are, and given their tone and content, I now have a question about the heart and soul of today's policing. If somebody like me, who is such a supporter of law enforcement and loves and respects them as much as I do, has begun to worry because of these posted comments about the heart and soul of law enforcement, what do you think neutral public people or cop bashers who are looking for anything to paint you in a particular way are gathering from this? Here's an example. I'm sorry. Scenario 5. Do scenario 5. Read it and discuss it. And I will tell you, the comments in scenario 5, I got off an internet site where only police officers can post. And I know about trolls, but I'm sorry, you're not going to convince me that all of these comments are posted by a troll. There's too many of them, and I know you guys well enough to know, especially with some of the language, that's a cop talking. Sorry, you can't fake that.